It's 2025 and a new year means brand new opportunities. And for a lot of you out there, I know you've been thinking about one thing over the holidays, and that is starting your own business. But you have so many questions like how do I get started? How do I come up with a brand? How do I even sell stuff to people? And what am I even going to sell? Now take a deep breath. Shopify has got you. Shopify makes it simple to create your brand, open for business, and get your first sale. And you can get your store up and running easily with thousands of customizable templates. You don't have to be a coding nerd or a design geek to get this done. All you need to do is drag and drop. Shopify also helps with the details like shipping, taxes, and payments from one single dashboard, so you can focus on the important stuff, like growing your business. Established in 2025 has a nice ring to it, doesn't it? Sign up for your $1 per month trial period at shopify.com/truecrime, all lowercase. Go to shopify.com/truecrime to start selling with Shopify today. Shopify.com/truecrime.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my mythic co-host, Brett.
Alice, I wish I could appreciate that pun today, but I am a little beside myself right now.
I know. I thought about not going for the guttural there, but we are here last minute because this is a last minute filing. Last minute in the sense that it's been filed from the past 18 hours, 12 hours. I don't even know how many hours, but we are here to discuss a motion for a Frank's hearing that Richard Allen's attorneys have filed. And if you are not familiar with Richard Allen, he is the man currently charged with the murders of Libby and Abby, the Delphi murders. This is a surprise because there was no deadline to file a motion or anything. This kind of just appeared on the docket this morning, very early. And it is a long motion. It is about 135 pages, and it comes with many footnotes, many exhibits. Many of the exhibits are confidential, and a lot is discussed in this motion, including something that a lot of people have been wondering: how the girls died, how they were found, and many other gory details that are incredibly headline grabbing. But what is not discussed in this motion is the legal relief that this motion is styled in, and that's a legal relief for a Frank's hearing. So there is a lot to discuss here. We are not discounting this motion because a lot is said here, and we're going to discuss why this motion is styled the way that it is, and also to tell you what a Frank's hearing is, if you don't know what that is, and whether this motion is really asking for a Frank's hearing. And of course, the question that everyone's wondering: what does this mean for the prosecution of the perpetrator who is responsible for Abby and Libby's murders?
Yeah, and look, a motion for a Frank's hearing, not unexpected, happens a lot. Probably one of the hardest motions to get granted. But it's not surprising that you see it in this case, because one of the key pieces of evidence was a firearm that was found at Richard Allen's house. And that firearm matched a bullet that was found between the bodies of Abby and Libby, which is obviously an important piece of information, combined with some statements that Richard Allen made, putting himself in the park at the Delphi, the Monon High Bridge, at basically the time this was happening. If you're familiar with this case, you know about Bridge Guy. You know that Bridge Guy was filmed by one of the girls on a cell phone, and Richard Allen basically describes himself as the person on that bridge. And that combination of those things, along with recent revelations that he may have confessed to his wife, made this feel like it might be headed towards a guilty plea. Might be sort of an open and shut case at this point. Well, then we get this motion, styled as a Frank's motion. And I just want to read you the first sentence of this motion, because if you're not familiar with what it says, this is going to blow your mind. This is the very first sentence of the motion. Overwhelming evidence in this case supports the following. Members of a pagan Norse religion called Odinism, hijacked by white nationalists, ritualistically sacrificed Abigail Williams and Liberty German. And that sentence is essentially what the vast majority of this document, probably 120 out of those 135 pages, is about. The theory of the defense, which apparently they intend to put forward at trial, that Abby and Libby weren't murdered by Richard Allen, and they weren't murdered by a single person. Rather, they were murdered by essentially a satanic cult as part of a ritual sacrifice that happened in this park in Delphi. That may seem like a lot. It is a lot. It is a, there's that old saying that I forget exactly how it goes, but it's like, it's extraordinary claims require extraordinary evidence. And this is an extraordinary claim. This is the kind of claim that you thought died out in the 80s and 90s when the satanic panic ended. I mean, this is essentially, if West Memphis 3, if everything that the prosecution told you happened in West Memphis 3 actually happened, that's what we have in this case.
And kind of one thing to note about this, when we've talked about satanic panic types of cases where the prosecution or the defense has seized upon something that's been in mainstream media, that everyone's talking about this. One thing to note here is that before this filing, I will say I've never heard of this particular cult. I would say a lot of people probably haven't heard about it because they actually spend a good vast amount of dozens of pages to explain what this particular cult is so that it can fit into the narrative they're about to tell the judge as to why the evidence supports that this particular cult is responsible and not Richard Allen. I note this because it does, even though it may be seizing on, I don't know that there's currently a satanic panic thing going on right now, but it is certainly different than other cases we've covered where there was a tactic or a theory of satanic panic, because here we are not seizing on something that everybody knows about, that it's in the media, and we're able to grasp and say, oh yes, I've been hearing about this on every channel, every podcast, everyone's talking about this, and see, here's the real life example of how this fits into something I've heard everywhere. And I think that's important to note here. And a lot of you probably, as we read the first sentence of that motion, are saying, what? Are you pulling our legs? Is this an April Fool's episode? What are you even talking about? I can't wrap my mind around it. To be honest, that's how I felt for the first dozen pages of this motion. I do note that difference here.
And look, if you read the motion, it's available online, and they go into a lot of detail about what Odinism is. And they go into a lot of detail about these people who apparently practice this faith, cult, whatever you want to call it. And this notion that these people would engage in some sort of human sacrifice as part of that cult. But before we get too much into the cult stuff, and I realize the cult is kind of like a black hole. Once you start talking about it, it sucks you in. That's all you want to talk about. Remember, this is styled as a Franks motion. A Franks hearing says, you had a search warrant, and if you look at the affidavit, the four corners of the affidavit, you have probable cause to support that search warrant. So you can't challenge it on the face of the document. And ordinarily, if you can't challenge a search warrant on the face of the document, you can't really challenge it. If you want to go beyond what it says in the four corners, you have to allege that the officer who filled out that affidavit and swore to it lied, essentially, either by misleading the court intentionally, and it has to be intentional, or with reckless disregard for the truth. It can't be negligence. It can't be simple mistake, ignorance, anything like that. It has to basically be an intentional misleading. That's the first thing. Something that's either left out or put in, left out that should have been in there, and we'll give you some examples later, or something that's put in there that is not only wrong, but is intentionally wrong, and that if the thing that was left out was put in there, or if the thing that was wrong was correct, then you wouldn't have probable cause in the affidavit. That's step one. If you meet that standard, then you get a hearing. So first you have to show that. Then you can get a hearing, and then basically everything comes in. You go outside the four corners of the document, and now you really just, it's a free-for-all type hearing to show that there really was probable cause to do a search. Frank's hearings, they almost never succeed, and this one is not going to succeed. Because this is not actually a motion for a Frank's hearing. This is a press release. And this document was put together I think for basically 3 reasons. Number one, to affect the jury pool and to do it ahead of the trial. Because if the first time we heard about Odinism and human sacrifices was in the opening statement, the defense attorney wouldn't be able to finish it because the jury would laugh him out of the courtroom. So it was important for them to get this all out there beforehand so that people were talking about it. It was in the bloodstream. People knew about it. And now it's like something that is a serious consideration for the jury, for the future jury.
And something to note about that, Brett, we didn't plan this, by the way, but that's why it's important to note what I just noted, that this is not, Odinism is not something that we're hearing about out there, right? They had to prime the pool because when I read Odin this morning, I was like, I had to immediately Google it because I kind of heard of it, kind of knew it had something to do with like Norse gods maybe, but I didn't know what it was. So that's really important to note right there. You have a big education period right now for most people who've never heard of Odinism, or if they have, they don't really know what it is. Is it a religion? Is it a cult? Is it just myth, like that we read about or learn about in school? Or is it something much, much darker and capable of murder of 2 young girls?
Right. And look, a lot of you reached out to us and you asked about this and you said, isn't this the kind of thing that normally come in at trial? The vast majority of this is exactly that. It's not actually about the search warrant. You don't really get to search warrant stuff until page 105. They mention it briefly in the beginning. Then they talk about Odinism for 80 pages, as if the police officer was supposed to include all this Odinism stuff in his affidavit. He doesn't have to do that. If there are alternative suspects, he doesn't have to do that if he's trying to show that this particular person, there is evidence of the crime in this particular person's home. I mean, for all he knows, Richard Allen's an Odinist too. Like they deny that at the end, but that's not really for him to decide.
And we're jumping around a little bit here. We'll cover it in more detail. But one of the things that they claim in this motion is that because there's so much evidence of Odinism in this crime scene, or who could have done these murders, that somehow there's been a failure by the prosecution in their affidavit by not alleging that Richard Allen has any ties to Odinism. Remember, in any investigation, there can be many search warrants. In fact, there probably are many search warrants in a case as big as this one. And the only thing that he gets to challenge is the search warrant that was served on him for his house, the search of his property when they found all those things earlier this year or last year. I've lost track of time. Not into other search warrants. And remember when we actually covered the search warrant affidavit many episodes ago, we talked about how there are certain lines in every affidavit, including this one, that notes things like, this is not all of the evidence that we have in this case. We are giving you the relevant information in order to establish probable cause, not beyond a reasonable doubt, probable cause that evidence of the crime can be found here. You don't even have to allege that evidence that he is the killer will be found here, but rather evidence of the crime can be found on this property. We see this a lot. Remember, if someone hides out in someone else's house or a car, it's not because the property owner, we think they are the murderer, but we think that they may be in possession, maybe unknowingly, of evidence that goes to this investigation. So make clear of what we are supposed to be challenging in this motion.
Yeah, and what's interesting about this entire document is there are things in it that are interesting. Like there are things in it about the crime scene, about some of the things that were done that I think do a pretty good job of making you wonder if one person could do this, which was one of the things they wanted to accomplish in this. The Odinism stuff is, I guess, useful. It is difficult. They're going to have a heavy burden to carry, I think, to convince people in a courtroom, which is what eventually they're going to have to do, that this was some sort of Norse pagan sacrifice to ancient Nordic gods. I mean, just saying these words, it's amazing. This year, it's like Brian Koberg. It's like these guys saw Brian Koberger's lawyers, and we're like, man, we got to one up those guys. And they saw Poot and Jim in South Carolina on the Murdaughs, and they're like, we got to get in on this. We got to get in on this action. And so they filed. They've trumped them all. I mean, in Idaho, you got a guy filing a motion that the grand jury procedure that's been used for 130 years is invalid because it's not beyond a reasonable doubt. You got Poot and Jim claiming one of the biggest misconduct claims I've ever seen, that a member of the courtroom staff basically manipulated the jury. And then you get
I mean,
this, you get
this has been a
Odinism.
year of extraordinary circumstances. But one thing I want to seize on before we keep discussing, Brett, that I think is really important, we're not saying that this is not all smoke and mirrors. I don't know. I haven't dived into the evidence. Most of the evidence is confidential, actually, even as their exhibits. I am not alleging, because it's a very serious allegation, to say that these attorneys have made up this evidence. I'm not saying that at all. I'm going to take at face value that everything they cite is evidence that they've reviewed. What this is, though, is their spin of the defense that they would put on at trial. It's their interpretation of the evidence and also the narrative that they would want to tell at trial. It's not actually challenging probable cause for the search warrant against Richard Allen. So make clear, Brett just said this isn't going to succeed. He's pretty bold in that. I don't know. I don't know what to believe in the courts anymore right now. But I want to make clear that we're not saying that the lawyers are lying here or making up evidence, but they are absolutely spinning the evidence that they are choosing here to tell their story in a way that they have not gotten to do yet. Think about the prosecution. They've gotten to have how many press conferences at this point to tell their version of what they think happened? The defense hasn't really had a chance to do that. I know they've had they spoke to the press at first and then they couldn't speak anymore because there's currently a gag order, which means that they cannot speak to the public about their story. So this is kind of their only avenue, a public filing, in order to tell their side of the story of things. This is perfectly what I would expect them to do at trial when it's their time to give their opening statement. And because of the subject, you can imagine that they have to do it the right way. Otherwise, they will be laughed out of court. So this is why at the very beginning, before we began recording, I said my favorite footnote in this whole motion was footnote 15. And the reason that's my favorite footnote is, to me, that footnote wraps up in a pretty package in one footnote what this motion is. So I'm going to be paraphrasing. I'm not reading footnote 15 right now directly, but basically in the body of the motion, they say something like Odinites are even guarding Richard Allen in prison. And because they're guarding him and filming him in a certain way, it's keeping Richard Allen from being able to express freely things to his attorneys that would be important for his attorneys to know. And in quotation marks, they attribute a statement to Richard Allen in the body. And the statement
I got to read it.
Okay, the statement they attribute to Richard Allen is...
So they say, Richard would therefore not be able to privately discuss anything with his attorneys, such as, quote, the guards are telling me that my wife and family will be killed unless I call my wife and tell her that I killed these girls.
And then in the footnote 15, so that's a very, very intense quotation for Richard Allen. But then there's a tiny little superscript 15, and you have to go all the way to the bottom of that page. And if you want to read along, it's page 22 of the motion and go all the way to tiny font. I don't know. This is like 8 or 9-point font. I think 9-point is like the default font for footnotes for Word documents. So I think it's 9-point font. It looks smaller to me though, so I think it is made smaller. And it says, footnote 15, directly after the quote that Brett just read you, it says, to be clear, up to this point, Richard Allen has never spoken these words to his attorneys. The point is that the Westville guards have made the privacy needed for Richard to have that type of private conversation with his attorneys very difficult, and perhaps not worth the risk if you are Richard Allen. The whole point there is that's not anything he said. I don't think they're being misleading, and I think they put that footnote in to make sure that they weren't called out for being misleading. But you can see how this motion and footnote 15 shows you that this is their telling of the defense. This is their story for the defense. And it's okay. You're allowed to have a story, especially if you're going to go to trial. But this is not what happened that we know of so far.
Yeah, and I mean, the last time we talked about this case, the thing we talked about is how are they going to get around the fact that he confessed to his wife? And we couldn't come up with a good reason. And we were like, well, maybe they're going to say he's crazy, he's incompetent, and so he just confessed. And here you go. I mean, this is what they've come up with. There is an Odinite conspiracy in Indiana, which involved the sacrifice of these girls. 2 of the guards who work there have Odinite patches on their shirts and maybe Odinites. And so what must have happened is they told him, if you don't confess to your wife on the phone, we will kill your wife. And that's why he did it. Now, he's never told us they said that, but that could be what happened. I mean, that's essentially what they're doing. And look, it's brilliant. It's brilliant PR because you're already seeing people lapping this up, people just taking it and running with it. The same people, by the way, who for 20 years, and I'm not saying they were wrong about this, 30 years, thought that like the whole West Memphis 3 thing is just crazy. Like, oh, Damien says he's a Satanist and he wears black and listens to Metallica. Well, that's silly. What a silly conspiracy theory. Only a bunch of rubes would believe that. And then you see people just grab this and run with it. Oh, Odinites. There must be an Odinite conspiracy. And maybe it is. There's some interesting evidence in the document, but this is this is something. And once again, these are the same people, the same defense attorneys who filed a motion saying that Richard Allen was basically being starved, tortured, and everything else in prison. They took a picture of him wearing this dirty shirt. And then the prosecution comes back and says, no, that's a shirt he wears whenever he works out. He eats all the time. He reads a bunch of books. He likes to hang out alone, and basically just blows their whole thing out of the water. This will not stand alone. It will be rebutted, and it will be rebutted by the prosecution. And I think one thing it would be nice if everybody could do is just take a breath, take a step back, and see what the response is, because I have a feeling it's going to be kind of like the prisoner of war filing by the defense.
Prisoner of war filing. And that's a really great point. To be honest, we did plan to have a live tonight. We did not plan to talk about this filing today. And I kind of didn't want to talk about this filing either, except for the fact that I knew there were going to be all these headlines and people would be hyperventilating and didn't know how to think about this, right? Because it is written like a novel. It's like Brett said, it is fantastic PR. Now we're all talking about Odinism. And unfortunately, they have included things in here, even if you didn't care about Odinism, even if you thought this was grasping at straws, they have made it a very interesting read for everyone because they have included information in this motion that has not otherwise been revealed and is a tactic to basically get people to read this. And I felt very, very uneasy reading it. And you can tell, exactly where I'm going because it's section 1 of after their, 40-page introduction. Section 1 is the crime scene. And they go in absolute detail for the sensationalism of what's happening. And here's the thing. This is very smart of them. They're able to do that because typically when you are defending someone who is charged with murder, you don't want to talk about the murder scene very much. You don't want to talk about, the suffering of the victims because that's not going to look great for your client, even if you're saying he's innocent, because people are left with, oh my goodness, this is devastating, these young children. But because they're painting this fantastical story about Odinism, the more attention grabbing they can make the crime scene, it's already attention grabbing, the better for them because something so wild, something that people have not really been able to put an idea to, all we know is it was terrible. We didn't know what it was. The more they are able to essentially tell this like a story, the better for their theory, because their theory, the more extraordinary your story has to be. And this all fits in together. So I do note that, like, even if you don't care about this motion, people are all reading it because it contains information that was not otherwise public until this point.
And information, by the way, that's not necessary.
No, absolutely not necessary. You do not need this for the Odinism theory at all. That's why I think they've included it as section 1, because it makes everyone want to read it no matter what.
Yeah, and whatever. People want to praise them as being they're looking for the truth. They did not have to include all these details. It wasn't necessary to what they were doing. Even if they wanted to describe,
first of all, I want to say sorry to Abby and Libby's family members. I don't know that they didn't have to know all of this. I don't know if they do know it, but to have this blasted out on a public docket, not redacted. By the way, when you make filings as an attorney, you always have the ability to file things under seal or redacted. And you see that they know how to do this because they attach exhibits. And most of the exhibits, because they're crime scene photos, are confidential, but very minute details of everything they're describing that's confidential is not redacted. And that was on purpose. And you typically do that, by the way. There are local rules. I haven't checked the local rules for this particular jurisdiction, but in just about every jurisdiction, there are local rules to provide for this particular instance where there's sensitive information that maybe the court has to know, has to hear, but the rest of the world doesn't need to know at this juncture. Not only did the court not need to know these facts, it certainly did not need to be public. And the fact that it was just blasted onto a public docket, remember that there are people hurt because of this. And this is a very, I truly pore over every word that I write. And I think about every word that I write and whether it needs to be under a protective order, it needs to be confidential in some way, shape, or form, it needs to be redacted, or maybe there needs to be time to confer with the other side to see whether any information in there that's sensitive needs to be kept from public view for now, because it's not necessary.
And we talk about that sometimes. And we talked about in this case. I mean, we said, like, the bad thing about this is once you arrest someone, eventually a lot of the details are going to become public. And people ask us, is there any way to protect the girl's privacy? And the answer is no, there's not. But that information typically comes out in a trial. Trials are public events. And, you know, there's going to be information that comes in. Now, the thing about that is the trial is a controlled environment with a judge who's deciding exactly what comes in and what doesn't, what details come in, what don't, what is shown to the public and what's not. And you see that sometimes, like in the Murdaugh trial, whenever there was sensitive information on the screens, they would make sure that the cameras didn't catch it. I mean, if you're in the courtroom, you're going to see it, but we're not going to broadcast it to the world. In this, you basically had these guys. I mean, they are describing what may be two people covered up by branches in a frenzied way to temporarily cover up the bodies, make them harder to find so you can get away, or could be an elaborate tree branch stick ritual by Odinites. That could be that, but they spend multiple pages going through that, telling you exactly how the bodies were arranged, where everything was, you know, just on the thigh. Here, there was a stick on this thigh, and like everything else. They didn't have to do that. They didn't have to do it, and they know they didn't have to do it, but they knew it would be sensational, and they knew it would make people read it.
Along those lines of being completely unnecessary is the number of times they said, for example, that Abby died a slow and painful death. Completely unnecessary, truly unnecessary, even for their Odinite theory, but was meant to be a stab in the heart to everyone who loved Abby and Libby over and over and over. I actually got mad when I read it for and this is not an exaggeration, I think it said over 24 times in the filing, and I got madder and madder each time I read it. Maybe it was because I'm a parent, maybe I'm a lawyer who really pores over each word as I put into it, but that was in there way too many times, and it was for sensationalism.
Another thing they didn't have to use these people's names. They decided to do that. They could have used initials. They could have used subject one. They could have done any number of things. Instead, they decided to make their suspects public because what they wanted to happen is they wanted people to go to their Facebook pages and do the side-by-sides. Oh, he looks like maybe he could be Bridge Guy. They wanted them to do that, and that's exactly what happened. They wanted to create a frenzy, and that's what they got. And including, by the way, one of the people they used who made some statements which appear to be very incriminating is someone who has the intellectual functioning of a 7-year-old. So, you know, I guess that's fine if you want to do that. Or maybe you should consider that these very damning statements may be coming from someone who doesn't fully understand what they're saying.
And remember, if you're joining us for the first time tonight and you're thinking we are reacting to this motion and these are just new things we're saying for the first time, everything we're saying tonight, we have said ad nauseum for the past 3 years. Remember when we've talked about charging documents in previous legal briefs and even in our other podcast, the prosecutor's podcast, we've talked about how if you are not the defendant charged in a charging document, we use initials. For victims, we never list out the entire name of the victim in the charging document or really any other public document. If you are not the one implicated in this crime, you are not the one being charged. If you are just a witness, even if you're another suspect or you're another co-defendant who's unindicted or hasn't been arrested yet or hasn't been charged, all of those names are anonymized in some way, whether by initials or by numbering or lettering systems. And the other side will know who you're talking about. So you're not keeping it from the other side in order for them to prepare their defense. But it's so that the world doesn't have to know every single name that's out there. Because you know who's been investigated in this particular case? The entire town of Delphi and beyond. And so there will be so many names in their case files of probably everyone who's ever, for example, given a voluntary DNA sample. We know from past statements by the police that they have swabbed hundreds, thousands of people, and most of these people have even come involuntarily. This will all be recorded, and this could be part of the case file. Does it mean that all of those people who came in voluntarily to give a DNA swab deserves to have their names splashed across public dockets for the world to read when they have nothing to do with the murders of these girls? No. And nothing in the court rules says that they can't use their entire names, but this is kind of a court ethic and a lawyer ethic of how you go about making very serious allegations about people when you're not the charging body, and they are able to get their story across and their defense of Richard Allen without doing so. So this is very outside of the practice norm.
And look, maybe they will be able to substantiate all this. And, at trial, they will unveil the just wildest story in the history of true crime. And for really one of the first times ever, there will actually be a ritualistic killing murder proven in the United States where members of a cult came together one afternoon in a public park underneath a bridge where all these people were hanging out and ritualistically murdered these two young girls. And then the police, after hearing this sensational story, one that pretty sexy story. Oh, and by the way, having a impressionable person with the IQ of a 7-year-old who probably could have been easily manipulated in a case where there was intense pressure to solve the case and pin it on someone, rather than going with the Odinite sacrifice conspiracy with a witness who could be manipulated, instead decided to spend the next 5 years actually investigating the case while under immense pressure and found Richard Allen. Why they would do that, like this notion that there is some sort of conspiracy, and it just bleeds through this document. It's not that they're inept. It's that there's, for some reason, these officers are intentionally not pursuing the Odinite angle and instead have decided at some point to go after Richard Allen instead.
And based on this document, these Odinites are still killing people, have killed people in the same or similar manner, and are incredibly dangerous people who should absolutely be, taken off the streets. They have not, again, if this were true, oh my goodness, blood boiling sort of situation. But why? Why? They have pointed to not even a shred of storytelling to close up the loop. It's hard to suspend all reality when reading even short stories, and this read like a short story. Why? Why would the police choose to do that when they have all of these jurisdictions at their disposal to pursue the right killers? It's not for lack of resources. We know that. So why do they love the Odinites? And how were they able to get even, we talked about the suspects that they've named, but also the guards that they've named as well, who they accuse of being Odinites as well. They list them by their full names. By the way, those people go to work every day with people who they are supposed to stand guard over, who will hear about this. I don't know what will happen to them. I hope that they are safe. I hope everyone who's listed in this document is safe. There has been a lot thrown in this document that is not impactless. In fact, outside of this case, outside of this prosecution, it has had massive ramifications already in a way that court rules exist to protect the rest of the world from having to undergo these ramifications. And one thing that I meant to note earlier is they are certainly seizing on something that undergirds this entire case. Remember at the very beginning of this investigation, we're talking like in the first 2 years, when truly no one knew who the suspects were and everyone in Delphi and the surrounding areas were pointing to each other. Do you remember what was happening? So much so that the police had to plead with the public not to do. Facebook profile comparisons. Remember what a huge problem that was? People's lives were being ruined by their fellow classmates and their fellow community members because people were literally going to Facebook and just typing up Jane Doe, Joe Doe, whatever, and pulling up a picture and saying, doesn't that look like Bridge Guy? And people's lives were truly ruined. And the police were like, please stop doing that. You're not helping law enforcement. When we covered the Delphi case on the prosecutor's podcast, we said that, I think, in our last episode. We pleaded with people, if you have information, go tell the police. Do not be an armchair detective in this instance, because there's so much that has been pulled into this case that shouldn't be, that we don't want to mar the investigation. And those Facebook side-by-sides absolutely happened in a frenzy. And you know who knew about that? Everyone in the world. So it's great that they have pulled that thread that has been part of the case since the very beginning and weaved it into their motion to essentially reinvigorate the public to do it again by giving you one Facebook profile to start with, and then like, have at it. Go for it. Go find more Odinism out there and pictures that match the crime scene that we've described in pages of painstaking detail.
And they picked a guy, unfortunately for them, who does have an alibi. He was at work. He has the time card to show that. So they speculate, well, maybe one of the other Odinites did the time card for him. Or maybe he's like Charles Manson. They literally mentioned Charles Manson in this, who was controlling the other people and they did it for him. Or maybe they started it and he showed up late. And it's like, guys, I mean, look, like I said, this may be very powerful in a trial if they can get it in, which is the other reason they did this. They needed to familiarize the court with this argument, because at some point they're going to have to convince the court to allow them to put this evidence on. Just because you want to accuse someone else of doing the crime doesn't mean you get to. You have to put some evidence on. You have to meet a prima facie showing that this is actually something that's viable, that you have real evidence, that it's not just meant to confuse the jury, that it's not irrelevant. That's another thing they're preparing the fight for. They're putting it in this document, but they know they're going to have to fight with the judge about this and get him to let them do this. If he does, look, the jury's going to eat this up. I mean, we love this kind of stuff in this country. We eat it up. Ooh, weird people who are different than us. Ooh, human sacrifice. Wow, bet they did it, right? And that's what they're going for in this. And it may be successful, but what's not going to be successful is the motion for Frank's hearing. I don't think. Alice thinks I'm going out on a limb too far. But I do just want to walk through some of the actual Frank's hearing allegations they make on page 105. On page 105, they start getting into their actual argument about the affidavit.
Let me explain the laugh so that people don't misinterpret, because I think there are a lot of heated emotions around this. So we laugh not because of any of the merits so far. Literally, the laugh was because, as we've said before, whenever you have a legal filing, judges are very busy people, and you typically front your legal request at the very beginning, first line, if not the first paragraph. And you do that so that the judge knows exactly what you want, because typically your filings are for an audience of the judge. In this instance, I think for all the reasons we've already stated, how this is outside of the norm of legal filings, this is not a filing for the judge. This is a filing for the public, and it's been effective in that instance. So the chuckle from us is that the legal ask didn't come in the first page, what you're supposed to do typically, what you learn in Law School 101. It comes on page 105, which is longer than, about 100 pages longer than most Frank's motions will be.
And the title of part 3, once again, this is a Frank's motion. The whole point of the Frank's motion is to show that evidence was concealed or falsified in the search warrant. On page 105, they finally have a section that reads, Liggett concealed and falsified evidence in his affidavit for a search warrant. So in this motion for a Frank's hearing, the section that actually makes the Frank's argument is on page 105. And the things they talk about, I don't know if you guys have looked at the search warrant affidavit. It kind of just got glossed over. Everybody looked at the affidavit for the arrest warrant. We talked about when it came out that there was a search, so there would be a search warrant affidavit as well. It eventually did come out. It pretty much was the same as the arrest warrant, just without the bullet information, essentially, that it matched a gun that was in the house. But the key parts of it are when Richard Allen first spoke to someone about this case, he said he was on the trail at exactly the right time. He saw a bunch of girls, though he didn't see the girls. He's either looking at fish or checking his stocks. It's a little unclear. He was on the bridge. He was wearing the right clothes. I mean, he basically just he parked at the old CHS building. There's all that stuff. They can't really challenge that. I mean, they basically say, well, later on when he talked to him, he said he left a little earlier. They didn't put that in there, but I'll just note that when you change your story, that's usually bad for you. So even if they had have included that in the affidavit, it would not have been good for him. The things they also included, though, were other sightings. About 5 or 6 people who described a person on the trail generally matching Bridge Guy's description and essentially lining up with Richard Allen's own story of him being on the trail. And they point out some things that are in the affidavit that are either incorrect or a little off. And these include this. Well, first of all, they talk about how they focused on one of the sketches over the other. I don't really know what that has to do with the affidavit. That always seemed weird to me, too. Everybody thought that was weird because the 2 sketches are completely different. One looks like Bridge Guy. The other one looks like a kid, basically. That was strange. Okay, that's going to be a good argument at trial, again, that people saw someone who looked very different. They focused on the fact that Betsy Blair says she saw a car at 2:15 p.m. that didn't match the description of Richard Allen's car. So in the affidavit, they say she saw a car there, and it was unusual because there weren't usually cars parked there, and the car was backed in. Doesn't use her description of the car. There's another guy who comes along and uses his description of the car, that he saw it and it looked like a small SUV or maybe a PT Cruiser, I believe is what he said. And that guy said it was a black car. Richard Allen's car is black. Betsy says it wasn't a black car, and she said it was more like a 1965 something. And they're like, well, they should have included that. Well, this should give you an idea of the issue here. This is ticky-tack stuff. This is stuff that if he had have included it or if he hadn't have included it, it wouldn't have changed the central question, which is, was there probable cause for the search warrant, which is a pretty low bar.
Right. And remember, this is not to challenge whether he was rightfully indicted, just for the search warrant. I think that's very, very important to be underlined here. A couple things I wanted to note that may be questions for you if you read this 130 plus page motion is they make a lot of hay up front that there's been all of this exculpatory evidence that's been withheld by the prosecution. And they say it multiple times. They use those buzzwords, which you all know because we've used them a lot. Exculpatory evidence not given to us and hidden by the prosecution. Those are very serious allegations, and if you were to violate that, that is a Brady violation. We've talked about this before. Let me be clear. They're not actually alleging a Brady violation here, and they don't go so far as to even say that because they can't, and here's why. Exculpatory information does have to be turned over before the start of trial. In other words, it can be turned over on the day of trial. We are eons away from trial. Discovery is typically ongoing. Discovery is going to be voluminous in an investigation like this. So they kind of try to have their cake and eat it too. They say, we've been document dumped. On September 8th, they dumped all these documents on us. We are drowning in documents. And court, it's possible we've missed all the links to our guy because there's just too much evidence for us to go through. And then on the other hand, they're saying they've withheld all this evidence from us. Read those with your open eyes and open ears. There's something weird about that, and that's because it is weird. There's been no Brady violation thus far. Let's say if trial started and a bunch of evidence that could go towards their defense, what they've described, I would say, yeah, that could go towards their defense. That would be exculpatory information. I'm giving them utter benefit of the doubt. But the fact that it's been turned over, and they said that it's been turned over, means that there has not been a Brady violation. And the prosecution didn't wait until the last minute. Like, trial is so far away from where we are standing right now. And these are continuing obligations that you have all the way until the day of trial. And then if trial starts and you find out Brady information after the start of trial, the rule is just that you turn it over as soon as you get it after the start of trial. But that obligation to turn it over as soon as you get it doesn't actually trigger until trial has started. So be clear about that, because that's a very serious allegation. And the other thing being that there's so much evidence and the prosecution is doing it on purpose to bury them. I think they use the phrase, the evidence for the Odinites is buried like a needle in a haystack of evidence. This type of case will have mountains of evidence because it was a multi-year investigation by multiple jurisdictions, and we know that they investigated many leads. What probably happened is that they got the case file with a bunch of leads that ended up being dead ends. And it appears, I don't know because I've never seen the case file, it appears that the Odinite angle was probably taking, at face value, everything they've said in their motion. The Odinite angle was investigated and ultimately, so far, is not the path that they're going with for purposes of Richard Allen. That's all their motion tells me so far. And that's pretty normal, right? You're going to investigate those calls. You're going to investigate all the different leads you have. And just because you don't ultimately charge your guy based on one of the investigative theories that dead-ended doesn't indicate any sort of prosecutorial misconduct or law enforcement misconduct.
Yeah, and the other thing about this, what's interesting about the whole Odinism thing is, once again, it's hard for me not to look at this through the lens of this is supposed to be a motion for a Franks hearing. So I'm reading it and thinking, this is wild. And there's some actually interesting evidentiary stuff that makes you question whether or not this was done by one person. Though I'll just say, they go through this list. It's almost like we do with the you have to believe thing about what you have to believe to think one person could do it. And every time, everyone, I would be like, he had a gun. Next point. He had a gun. Next point. He had a gun, because he obviously had a gun. And you can do a lot with two people if you have a gun. And so they're like, somehow he would have had one of the girls buying the others. He had a gun. I mean, somehow he would have made them undress. He had a gun. So once they're dead, there's a lot of difficult things he also would have had to have accomplished. And I thought those are pretty effective parts of the document. But once again, they're effective in a, like, this is the case we're going to present against the prosecution, who has good evidence, but not a lot of it. And then we're going to pile on all this Odinism stuff. It's not good from the perspective of we are trying to suppress the fruits of the search, which is what they're trying to do. I mean, ostensibly, that is what they're trying to do, is get the judge to say, shouldn't have got an affidavit. And so therefore, the gun that matches the bullet doesn't come in. I mean, that is what the title tells you. The other thing they're trying to do is they're back to trying to get him transferred again, because they didn't succeed on their last transfer motion with the whole he's a prisoner of war thing, which means they still have to drive all that way, because it was always about them and how much they had to drive. So now they've come back with Odinites. These Odinites are in the prison, so we got to get him out of there. So now they have an emergency motion to transfer him. So maybe this time they'll succeed in transferring him. So I think, number one, they have definitely succeeded on their PR angle. No question about it. They may very well succeed in getting him transferred. I do not imagine they're even going to get a Franks hearing, much less be successful in one. But if they do have a Franks hearing, you talk about a wild affair. And I can't wait to see what the prosecution writes back in response to this.
I think it's going to be much more rooted in the evidence, and they're going to have to respond in some way to this story. I hope they stick to the fact of calling this out for what it is, which is it's not a motion for a Franks hearing. I think the judge will be able to see that, but it's going to be a lot less sexy of a response than the initial motion. And we're going to say something here that we say for just about every single one of our episodes. Go read this document for yourself if you'd like. Don't take our word for it. You know, we do have experience in these because we respond and read Franks motions all the time. We have Franks motions. We make prosecutorial decisions and investigative decisions and go down certain investigative paths that end up being dead ends. We file for search warrants all the time. So this is from our experience of filing these documents. Again, we are not casting dispersions on what they say is evidence or not. I'm saying accept all that they say as true. I still think this is their opinion of it. And this is them priming the judge and the public for the ultimate defense at trial, because so far nothing else has stuck. And they're going to have to tell a very, very big story to explain away a lot of things, like Richard Allen confessing and the bullets and the guns. And there's a lot of evidence in the affidavit for the search warrant. You can go back and read kind of the prosecution's evidence that they've laid out as to why there's likely to be evidence at Richard Allen's home. And then they ultimately brought charges against him. It was a very strong affidavit as we read it. And now this is their other side. We always said there are two sides to every story, and you're beginning to hear theirs. They're smart. You otherwise would not have gotten a preview of the defense's story if it were not for this Franks motion.
And I think one thing the defense is hoping to see, and I think they will see it, is, they're also getting a preview of what the prosecution's response will be to their defense. The prosecution, for all we know, has us pretty locked up on these guys. We know their position on these Odinites and what they were doing. We don't know what the prosecution's going to say back. It'll be interesting because honestly, the prosecution could just respond to the Franks part and be like, yeah, okay, Odinism, that's great. Let's talk about the affidavit and what you say we left out and what we should have put in it. These are relatively minor things. You assume everything you said is true. And everything you said should have been in there, should have been in there. And everything you said shouldn't have been in there, shouldn't have been in there. And guess what? Still have probable cause. And that's the standard for a Franks hearing. And that's the standard just to get a Franks hearing. Once again, that's what you have to do to have the evidentiary hearing where you get to cross-examine the person who wrote the affidavit, who will then explain why he said that the person was muddy and bloody, but maybe they were only muddy. Though the woman also said they looked like they'd been in a fight, which could have been interpreted as bloody when the guy was writing the affidavit. I mean, that's the kind of stuff you see in this motion. The one thing I'll say, we always tell you to read things. I'm not going to tell you not to read it. Just know there's some graphic descriptions of how the girls died. And I know a lot of you don't want to see that. You can probably, there are parts you can just sort of skip around. You can read the parts about Odinism. You can read the part about runes and whether or not they were runes at the site and the runes on the tree and all this other stuff. And Facebook posts made by the people they're accusing of being murderers and all the other stuff. You can read that and maybe skip over the parts that detail the way the girls were killed, the way their bodies were placed. I know that's something a lot of you guys don't want to see, but it's 135 pages. So even if you skip that part, you'll still have a lot to read.
Well, I know there's probably still a lot of questions and a lot of thoughts, and we've had this motion for about 12 hours now. So there's more that I'm sure we'll end up talking about, but we've already gone for an hour now, Brett. So before we sign off, is there anything you'd like to add?
I mean, I would just tell people don't go crazy. You know, it's so easy to get yourself spun up and Twitter and Reddit and Facebook pages and everything else. Don't do that. Remember the family. You know, I can't imagine what they're going through. You know, another thing the defense didn't have to do was cite to one of the girls' grandmothers. Probably could have left that out if they wanted to, but they didn't. The other thing I would just say is see what the prosecution has to say. Get both sides of it, read them both, see which one you think is more convincing, and go from there.
And we have said before, reading the affidavit for the search warrant and also in how this case has been handled since, you know, the investigation and then with the charging, nothing that I read in the motion caused me to throw everything that I knew about the case out the window. It was additional information, but it didn't cast doubt on everything else. So read it with an open mind. And also remember, this is one side of the story and more is to come.
The only other thing I'll say is we may not know all the details of this. It is certainly possible Richard Allen did not act alone. You know, I think there are people involved in this investigation who've never believed it was one person. It is hard to keep that kind of secret. This is a pretty big secret to keep amongst several people in a small town over that much time. But it's possible he didn't act alone. And a lot of the evidence in this document doesn't necessarily say he didn't do it. It just may say that the prosecution's current theory of the case, that he acted alone, is inaccurate.
And remember what happened when they had the press conference to charge Richard Allen. I don't have any insight into what the prosecution is investigating, is not investigating. But remember, they said this remains a very active investigation. I mean, that was something they said at the press conference. I don't know what that means. And we have brought charging documents before against one member or multiple members of a conspiracy, but not everyone in the conspiracy before because investigation remains ongoing, or you may not have enough evidence to charge everybody, or you are trying to get charge the people you know you can convict most easily because you have the best evidence against them in order to work your way up the chain to understand and uncover the full conspiracy. I'm not saying this is what's happening in this case, but that's certainly a tactic that we have used before, and that's used oftentimes in prosecutions because these are typically very complex cases like an onion that you have to peel back and you have to start somewhere. So with that, until next time, Brett, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. sorry. Let me make sure before I do the intro, the exact motion. Okay, motion for Frank's hearing. All right, here we go. Let me get my microphone. All right, y'all ready for this?
I don't know, guys.
There's a lot in that motion.
It's something.
It is something.
I mean, I've never seen anything like it.
Yeah.
I don't.
I've never seen anything like it.
It's gonna be if this goes to
I've
trial.
seen that a lot.